International protection in Irish law. There's a lot of controversy at the moment about asylum seekers and people coming to Ireland looking for asylum, looking for international protection. Some communities, some people are opposed and are claiming that Ireland is full, and on the other hand, the government is to stop this open borders policy which they say they've adopted. The government and the state on the other hand are saying that there's no open borders policy, that it's a rules-based process. Let's have a look at that and let's see exactly what's involved in international protection in Irish law, in other words, seeking asylum in Ireland as a refugee. The key act when it comes to international protection from an Irish law perspective is the International Protection Act 2015. This act covers things like qualification for international protection, application for international protection, the process, assessments of applications for international protection, examination of applications at first instance, appeals to the International Protection Appeals Tribunal, declarations and other outcomes, and more. Section 34 of the International Protection Act 2015 sets out the examination of application. It says that an international protection officer shall examine each application for international protection for the purposes of deciding whether to recommend that the applicant should be given refugee declaration, or the applicant should not be given a refugee declaration and should instead be given a subsidiary protection declaration, or the applicant should be given neither a refugee declaration nor a subsidiary protection declaration. Section 21 of the Act deals with inadmissible applications, and this is the first process when an application goes in. An inadmissible application will happen when 1. Another EU member state has granted refugee status. 2. A country other than an EU member state is the first country of asylum for the person. 3. The person arrived in the state from a safe third country that is a safe country for that person. A country will only be recognised as the first country of asylum if the person has been recognised as a refugee in that country and he can still avail of protection in that country. A safe third country is a country if the person, having regard to the matters referred to in subsection 18, has a sufficient connection with the country concerned on the basis of which it is reasonable for him or her to return there, and he or she will not be subjected in the country concerned to the death penalty, torture or other inhuman or degrading treatment or punishment, and C, the person will be readmitted to the country concerned. So that is a safe third country. Section 22, subsection 4 deals with subsequent applications. It is possible to make a subsequent application for international protection if, for example, the circumstances change in the country from which they've emanated, or if there are significant circumstances or facts which have changed. There is a right to remain in the state until a decision is made by the designated body. The definition of a refugee is set out in the International Protection Act, and it means a person who, owing to a well-founded fear, and the fear must be well-founded, a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group, is outside his or her country of nationality and is unable, or owing to such fear is unwilling to avail himself or herself of the protection of that country, or a stateless person who, being outside of the country of former habitual residence for the same reasons as mentioned above, is unable, or owing to such fear unwilling, to return to it. So that is the definition of refugee as set out in the International Protection Act 2015. Acts of persecution are set out then in Section 7 of the International Protection Act 2015. Section 47 deals with the outcomes, including a refugee declaration and a subsidiary protection declaration. Subsidiary protection is an additional form of international protection that is complementary to refugee protection. A person for Eligible for subsidiary protection is not a national of a member state of the EU, does not qualify as a refugee, but faces a real risk of suffering serious harm if returned to his or her country of origin. Serious harm is defined as a death penalty or execution, torture or inhuman or degrading treatment or punishment of a person in his or her country of origin, or serious and individual threat to a civilian's life or person by reason of indiscriminate violence in a situation of international or internal armed conflict. Actors of persecution or serious harm then can be a state, can be parties or organisations controlling a state or a substantial part of the territory of a state, and it can be non-state actors, if it can be demonstrated that the actors referred to in paragraphs A and B, including international organisations, are unable or unwilling to provide protection against persecution or serious harm. A couple of important things you'd have to have a look at if you're interested in this area would be the legislation itself, the International Protection Act 2015. There's a link on my website, businessandlegal.ie. I have an article there about international protection in Ireland, and you could also have a look at the International Protection Office website, which is very useful. So what is the application procedure then for international protection? The process for making an application for international protection can be found on the International Protection Office website. Basically, it involves a preliminary interview, and after the preliminary interview, your application for international protection is deemed admissible. You will have to fill out an IPO questionnaire. You are advised to obtain legal advice before completing the questionnaire. Then there's the question of a personal interview. After completing the IPO questionnaire, you will be invited to a personal interview. The personal interview is a substantive interview and is your opportunity to speak to an international protection officer from the International Protection Office, face to face, to present the grounds of your application in a comprehensive manner, including giving a full account of why you left your country of origin or habitual residence and why you are unable or unwilling to return there. Your application for protection will need to be supported by documentation, and you'll also need details of why you're applying for international protection in Ireland. You need to specify the connection or the convention nexus, that is connection with race, religion, nationality, political opinion, membership of a particular social group. You'll need to explain the serious harm or persecution that you have a well-founded fear about. You'll have to explain, is the actor of fear or persecution a state or a non-state actor? You'll have to explain, was internal relocation an option? You'll have to have credibility, your story will have to be consistent, and you'll have to have documents personal to you which might support your application. The above are some of the factors you will need to consider carefully when applying for international protection in Ireland. Once a decision or recommendation is issued, you are entitled to appeal it to the International Protection Appeals Tribunal. If you're unhappy with the recommendation, you'll have 10 or 15 days from the date of notification of recommendation to make your appeal. I hope you find this video useful. If you do, I'd appreciate if you gave it a thumbs up down below. And if you're listening to my podcast, the Irish Law and Small Business Podcast, on Spotify, iTunes, YouTube, or wherever, I'd appreciate if you followed it or left a recommendation or review. Thanks a lot.